At the end of the second quarter of this year, 2021-2022, we've noted an increase in the cases before your courts. They have risen by 4%, from 512,000 to 532. So this increase of number of cases means that we need to devise strategies to reverse the trend by adopting a versatile case management strategy. 95,000 cases are pending in your courts, and they are older than 3 years. This one, we have really to devise a way of reducing this backlog by embracing those multi-door approaches of seeing in your court station there is an active court annex mediation, and you encourage people really to embrace them, because people have the capacity to solve their own problems. All they don't do is that they don't speak to one another, and the mediator is there to facilitate them to be able to talk to one another. Especially family matters, I do not see what should be contentious, especially in a succession matter. Is it that the person who died, we don't know the wife, we don't know the children, we don't know the assets? Why would they quarrel? Because the law is so clear. If the husband died, the wife is the one who has the priority to get letters of administration. And if the wife is not there, it is the children. And the children, there is 1, 2, 3, 4, up to 4. You can give to the 4 of them the letter of administration, and then tell them, agree on how to share. And if you don't agree, come here after 6 months, and you just share it according to what the law says, equally among them, isn't it? They will come and bring you stories. Some are women, married, I don't know what. That's not for you. The law has settled it. So we can embrace many, many ways of ensuring that we finish the cases that delay us. But on a more positive note, I round and congratulate you for reducing the average time taken to conclude cases. During this second quarter, we have noted that cases are finishing within 289 days, and this we really need to appreciate. Clap for yourselves. This is indeed a positive trend that should continue and should serve as an inspiration for us to work towards even better performance. It means we can clear that backlog. I also wish to share with you that we will be gazetting the names of 119 judicial officers who have been identified for appointment as special magistrates to hear and determine matters relating to election offenses under the Election Offences Act, which includes hate speech. Courts prioritizing crimes of hate speech will be set up in select hotspot areas to deal with matters falling under the National Cohesion and Integration Act. We have mapped out some areas in Nairobi, Mombasa, Kisumu, this county, Eldoret and Nakuru. The NCIC has raised concerns about delays in hearing and determination of cases concerning hate speech, and we are conscious about that. And to deal with the problem, it will be useful if you, as heads of stations, do identify all the pending hate speech cases in your stations, and please work out modalities with the trial courts to fast track their resolutions, because this goes on to build the confidence Kenyans have with the judiciary to deal with the problems that we encounter. All pending hate speech cases ought to be concluded within 4 months from today, at least to give room for free, fair, and credible elections. Those who sabotage our electoral processes by inciting violence, and causing pandemonium should be dealt with firmly. A progress report on the implementation of this directive should be forwarded from each court station to the registrar of the magistrates court within 3 months from today for compilation and transmission to my office. In addition, all matters related to previous general election also should be concluded, and we are hoping this can be done by 31st July 2022. The small claims courts at Milimani have shown remarkable performance, and I'm grateful to the adjudicators there, led by the acting registrar, Madam Kanyere, who is present with us. Thank you very much for the good work you're doing there, under the leadership of the RMC and his office. As at 31st January 2022, we had recorded 5,000 matters which were filed in that court, out of which 2,300 have been resolved, and we have been able to recover 501 million shillings, that's $500 million, from those cases which were heard and determined within 59 days, an average of 59 days. We are now rolling out the small claims courts in other parts of the country. We have already gazetted 11 more small claims courts to facilitate access to justice. This has been done in Kajiado, and Thika have been operationalized. I also understand Eldoret is on the line. We will probably be launching it during this session. Plans are in advanced stage to launch small claims courts in Nakuru, Naivasha, Kisumu, Kakamega, Nyeri, Meru, Mombasa, and Machakos. Optimally, human resource capital is key. I also recognize that the current workforce in the magistrates' courts and also the caddies is not optimal to cope with the increasing workload. And in this regard also, I wish to mention the High Court, which is completely understaffed. Out of the complement of 200 judges, we only have 71 judges in the post. So we need judges, and I see many of them in this congregation. So we pray and cross our fingers we can be able to recruit quickly, so that we can be able to increase the capacity of the High Court even to deal with the disputes that are coming from the electioneering period. I'm aware that the workload per magistrate is 1,627 cases, with the sum of you handling even 4,000 cases. Recently, we recruited 64 additional magistrates, but it was just a drop in the bucket.